You're listening to News Talk Radio Guyana 103.1 FM, and we're also streaming live on Facebook, YouTube, and Twitter. And at this time, we are pleased to welcome. We're pleased to welcome you to this live panel discussion on the topic, the implications of the Representation of the People Act and what that means for Guyana. As you may recall, a few months ago, in fact, on August 2, 2020, the official declaration results were made in respect of the March 2, 2020 general and regional elections. And that, of course, stemmed from a long drag out from polling day on March 2, 2020. We heard various allegations of corruption, electoral fraud, and then with the People's Progressive Party coming into office, we have seen a situation where they have recently proposed amendments to the Representation of the People Act, as they say, to avoid any future controversy or attempts at electoral fraud in future elections. Going back a bit, we do recall also that the coalition of a Partnership for National Unity plus Alliance for Change had also leveled accusations of electoral fraud in Region 4. With me this evening to discuss this very thorny issue are attorneys at law Khemraj Ramjattan and Mr. Timothy Jonas. He's also Mr. Jonas is also the chairman of a new and united Guyana political party, and Mr. Ramjattan is the leader of the Alliance for Change. Gentlemen, welcome to this special discussion program on the implications of the proposed amendments to the Representation of the People Act.
Thank you very much, Dennis. I'm glad to be here with Timothy. Hi, Timothy.
Good to see you again, Khemraj. Good to be here.
Well, against the background of what I just shared with you, I'm almost sure that you may have had a look at the proposed amendments that have been forwarded and circulated by the government through the Minister of Governance and Parliamentary Affairs, Mr. Shearer. What are your initial thoughts when you looked at that draft for the first time?
You want me to go first?
Yes, if you don't mind, Khemraj, because I know you will have a specific issue.
Yeah, well, the specific issue is one of process, Dennis. And that process is the consultative process. Look, I believe that in a very sensitive area as this, electoral reformation, which is almost equivalent to constitutional reformation, it is important that everybody, be part and parcel of a process that would come up with a draft. And to see after one call it a debacle or whatever from March to August, and not wanting that to ever happen again, it is important that we do not get a draft that simply comes from the PPP. And that is my main concern here, apart from some of the contents that I will get into, because I think your program is about an hour long, isn't it?
So yes, Counsel.
Yeah. So it is important that we do not bypass those actual stakeholders that are supposed to have a big say in arrangements like these or reconfigurations that will ensure that which happened a year ago will not happen again. And I say so based on 2 points. And one has to do with only a couple of months ago, I think the PPP government established and constituted a law reform commission. And the Law Reform Commission, I think it was constituted, chairman is Justice of Appeal Roy, and we had Tenny Housty, Clarissa Reel. I can't remember all them. I think Satram is there and Apande is there. And the purpose is to update the country's laws, legislative amendments and all of that. And to quote the words of Anil Nandalal, and I hope I capture it correctly, he said it was to capture and embrace the aspirations, the exigencies, the social maladies, vicissitudes of society as it evolves and so on, so that we do not remain archaic, we are in sync with modern reality, and the country does not remain static legislatively. And this is a big part of an $8 million IDB project for justice improvement. And you have started the operationalization of that Law Reform Commission. And this piece of legislation, sensitive as it is, has not gotten into the hands of that Law Reform Commission. As far as I understand, this is exclusively something from the Attorney General. And that Law Reform Commission, now that it has been established and operationalized and has been given monies, and the IDB is there to ensure also that monies is granted to it, $8 million, well, not all of it, you have to have at least a participation by these experts that constitute them, that body. And by the way, the body also can hire experts and in elections from the Commonwealth countries and other countries and so on. They will have money for all of that. You didn't go there. You simply got what the PPP's reality is in relation to what the amendment should be, and you have taken it there. The other aspect of the matter, and it's very important, is that the GCOM itself is the main stakeholder here. And GCOM, up to Tuesday last, I spoke to some of the APNU coalition commissioners, and they have indicated that they did not deliberate or decide on any of these matters. And they are a major stakeholder. And in accordance with the consultative practices, if you want to talk about Article 13, they ought to have been at least asked for some measure of consultation with them for purposes of designing this new reconfiguration, this new kind of reforms that the PPP want. And to have a view from them. It did not happen. And this is not inclusivity at all. This is not good governance, in my opinion. This is not consultation. And those are going to be my opening remarks in relation to my critique of this.
Let's go now to Mr. Timothy Jonas. Your thoughts initially on the proposed amendments to the Representation of the People Act?
I agree with Khemraj's opening statement that this needs to be done as a consultative process, and that the sensitivities involved require a completely transparent process which includes everyone. That's absolutely important. Now, as you know, I have said time and again that if the government controls Parliament, we can consult and talk, but at the end of the day, the government majority will pass the law that the government majority wants in Parliament. Until such time as we have a minority government and a majority opposition in Parliament, we will have that situation. And both sides have enjoyed their exclusive control of Parliament in turn without seeking to solve that problem or to be inclusive, to include the other side. I'm sorry, Dennis, that you don't have a PPP representative in this forum, because if you want to have a good quarrel, you need both sides represented. And I'm afraid what you have here is not both sides. You have the APNU coalition side, and then you have what I consider to be a middle ground, So to try to remedy that, I'm afraid what I'm going to have to observe here in an attempt to be fair, because of the sensitivities here, it's important to be fair. I received a letter as a member of Anoin United Guyana, which is a small party, insignificant in terms of votes in parliament or anything like that, from Gail Teixeira, enclosing the proposed amendments and giving me a time frame in which to respond and make my comments. I understand that many of these letters have gone to various groups and bodies, many political parties, many private organizations, many private sector organizations. Now, a consultative process starts somewhere. Somebody's got to do the draft, share it around, and say, let's talk. And I don't want to jump to the conclusion that this is just a formality. This letter I received is a formality, and no matter what I say, the government is going to push through what the government wants to push through. Ordinarily, the government would do that. We've seen that happen with the PPP just in the last year. But this is so important, and tensions are so high that I believe and I hope that there will be some level of discussion across the spectrum in Guyana. And if that happens, the start that has been made, which is to say, here's a draft, let's talk, is the beginning of a consultative process that may go fairly. So I don't want to preempt to say, oh, there's no consultation and this is terrible. Because we've received an invitation from the leading party to put our comments on record, which to me is what consultation is about. Let's see where it goes from there. I do not put my head on the block for these people at all, but I can't criticize the start they have made. One criticism in terms of consultation, a criticism that I will make is that this is being done piecemeal. What we've received here are draft regulations under the Act, draft amendments to the Act, which add to the oppressive detail of the bureaucracy, which has the effect, rather than simplifying and creating transparency, to me, it has the effect of obscuring and making the thing more bureaucratic, making the processes more difficult to understand. And in our electoral process, everyone needs to understand. It can't be some detailed system that makes your eyes glaze over when you're trying to read it and understand it. It needs to be simple, it needs to be transparent, because that's where fairness comes from. And I hope as we go forward, we can find where the problems were, and having done so, make suggestions as to how to fix those problems, rather than making changes which create more problems because we throw in the baby out with the bathwater.
Okay, we'll get into the meat of what the bill says in a moment, but I want to ask you, Mr. Jonas, whether at all you agree that this process should have started with the Law Reform Commission, as has been suggested by Mr. Ramjattan, and thoughts by both of you. Aren't the governments, regardless of which party is in power, supposed to take the lead to get the process off the ground, rather than have everyone consult on what a bill should look like, and then you say, okay, we all agree? I mean, I've seen over my several years in journalism that governments basically take the position that they craft a bill, and then they say, come, let's talk about the contents. What's wrong with that approach? That's a question to both of you. But the question specifically to Mr. Jonas is whether you believe that the Law Reform Commission should have had an initial and significant role in this process.
The Law Reform Commission has been created for general purposes. I'm not satisfied that they need to take a lead role. There's no harm in including them and asking them for their comments. But they are there generally to update, to codify, to structure, and to streamline the entire body of legislation. Whereas here, we have an emergency and a crisis, and we are trying to legislate to solve the crisis that we have, the emergency that was created last year, so it doesn't happen again. So there's no need to exclude them. But again, I don't see anything wrong in the leading party who has control of parliament, who has parliamentary counsel sitting in the Attorney General's chambers whose job it is to draft legislation, who has the facilities, has the wherewithal to put forward a draft to say, please give me your comments. Let's have a discussion. I think that's how this needed to start, and it may have taken too long, but it's the way it's started.
Apart from the process leading up to where we are with this proposed amendment, do you really believe that the amendments are worth the while? Should we have had these amendments, or should GCOM itself have fixed its own systems to ensure that it can deliver an election that is free of all of the controversy that we have seen over the last few decades, particularly last year?
Well, if I may take that question, that is why I am saying GCOM is the actual institution. It is the stakeholder. GCOM knows more than anybody else what are basically the problems that occurred and what are some of the remedies that will ensure that they do not occur. And from a general sense, then, and taking the entirety of who then ought to have started off and initiate a process like this, I believe that GCOM, as an advisory body to us in Parliament as to what laws ought to be changed, what regulations ought to be made, and a whole host of other things in relation to electoral matters, because under the Constitution it superintends globally the elections in Guyana. It should have been, rather than coming, because what we will be having here, and as you'd appreciate, when the government or the executive branch comes up with whatever it wants as the remedies for what they felt happened there, and having the majority, they're going to ensure that this law as it is passed. They're not going to find anything wrong with it. And that is why when you miss that link, or you don't have the stakeholder involved, it's very difficult. You're going to have the Attorney General now arguing with everybody that this is the best piece of legislation. Life imprisonment for certain minor offenses in this act, and so on. And so once, it's like having a first impression of a certain individual. It's sometimes hard to rub away or erase. And that is why I'm saying that at least over the past couple of months, by when they started doing this thing, they ought to have asked at least a chairperson or some such member, or the better still, the entire body. Because in matters elections, this is this main stakeholder. This is the institution. And GCOM ought to have been involved. And so that is why I am saying, as a matter of process, it is like wanting to amend the judiciary or the judge's rules or some such thing, or some other matter that inherently lies with a certain other constitutional agency or entity. And then you, as the executive branch, say, well, all right, I got the authority. What it does not show is inclusivity. What it does not show is the fact that you want to consult, or at least tell them that we are dealing with some of these issues and so on. And that is my bugbear with it. And I think that is not modern, as was said as when they constituted the Law Reform Commission. That is not in sync with modern reality. And so I maintain that position and argue the point that at least if you didn't want the General Law Reform Commission, which got lots of experts there, and I prefer to also, I want to make this argument because it is also something that is preferable in a very polarized situation like in Guyana. Assuming that the Law Reform Commission had taken it on and come up with a thing, it would have been far more acceptable to the opposition. And you set up the body, and like so many other things that you establish under the Constitution, the Procurement Commission, local government elections to be held, and then you don't hold them, it starts making people suspicious, and especially, as mentioned by Timothy, the minutia The explanatory memorandum is almost nil as to all of these arrangements. It does not even explain it. So your party member asking what this section is talking about. A lot of people don't understand it, rightly as mentioned by Timothy. So you need, to overcome these things and overcome the suspicion that generally drives the Guyana's politics. And that start having been made, it's a false start, as it were. And it could tarnish the process to the extent of people, no matter what the quality of the thing, people will then say that I am not supporting it because of the bad start.
Or let's look quickly at the bill. I saw you just raised a piece of paper up just now.
Yeah,
It's
yeah, this
a
is it,
copy
the
of the bill.
amendment.
Right. Well, the proposed amendments, not the bill. What, to both of you gentlemen, what so far do you agree with in these proposed amendments?
Dennis, before you go there, could I touch on the GCOM question?
Sure,
Because
Counsel.
you raised that, and I understand Khemraj's answer and his position. There's no doubt that the expertise in conducting an election in Guyana lies within the GCOM Secretariat, within that body. And therefore, logically, you would say, ask GCOM. But this is where it gets thorny. This is where it gets difficult. And this is why you have to be so careful to criticize an approach that has been taken. There's no doubt that Keith Lowenfield, and there's no doubt that his predecessor, Gokul Budu, know much more about the processes of conducting an election than I ever will. They have the expertise. Who in Guyana will be satisfied if you go to those gentlemen to say, please tell us how to do those things, how to do this thing. Tell us how we can fix it. You have 3 members of APNO on one side and 3 members of the PPP on the other side of the GCOM Commission. And we had all kinds of problems for all kinds of months. Who in Guyana will be content if we delegate to those 6 individuals who continually stonewall each other and make no progress on any issue, including taking so far 12 months to find a replacement chief executive officer? If we say to those people, oh, please tell us how to fix this problem that you have created by your failure to conduct the elections properly in the first place. So it's a ticklish problem, because where the expertise lies is where the distrust lies. And Guyanese would not be content, and I certainly wouldn't be content, if we just wash our hands and say to GCOM, please tell us how to fix this thing. It's not as simple as saying, here's the expertise, you got to talk to these people. Guyana right now is about trust, and there is none. And that's the large issue. Who has the integrity? Who has the competence? Who has the trust to do this thing properly? And there's no answer to that right now. And that's the tragedy in our country. So it's a difficult question. And it's not just that you can simply say, why you didn't ask GCOM? I know full well why you don't ask GCOM. Nobody trusts GCOM. It's difficult. I'm not saying I disagree with Khemraj, because that is where the expertise is. But a consultative process must start somehow. And it's hard for me to criticize the way this consultative process started.
Okay. Before I ask both of you to respond to my earlier question, I'd just like to remind our listeners that you're listening to 103.1 FM here in Guyana, and we're also broadcasting live on Facebook and YouTube and Twitter. This discussion on the implications of the proposed amendments to the Representation of the People Act. And a quick response to one of our viewers on Facebook, who says that the hosts should have known a request was sent to GCOM to submit proposals. Well, it's not only a GCOM, but also all members of the political representatives of the political opposition, and I gather from the Minister of Governance, Civil Society. Now, back to my earlier question to both of you. What do you see as being good amendments in this proposed bill to the representation, amendment to the Representation of the People Act? Khemraj, Mr.
Well,
Ramjattan?
the actual representation of
What
People's
aspects would you?
Representation of the People Act. There are two sets of things here. The proposed amendments to the Act and also regulations made under the Act.
Right.
As far as I see and what I know, not what you are getting typed in there, this is what the regulations make clear, that they were made under Section 150 of the Representation of the People Act by the Commission, GCOM. And the templates and all the pages and the draft and so on, as far as I am aware, were never that of GCOMs. We're going to get more of that a little later. This came exclusively out of the Attorney General's chambers. And that is terrible. You do not propose that kind of regulations coming out of GCOM, and GCOM never deliberated or decided on it. But again, the argument could be made that you got to make a start somewhere. Well, at least ask GCOM to do the regulations on a draft piece. But you didn't meet none of them, and you got them now, it being purported that they made these first, I think it is 6 pages. That is not made by GCOM at all. And it is not even signed by them. It is normally signed by the chairperson. It is not here. But that's so much for that. I come down to the Representation of the People Amendment Bill, and it got a lot of minutia here. But one of the biggest pieces that I feel very critical of has to do.
But Mr. Ramjattan, what I'm asking first, we'll go to the critical aspects. I want to ask initially, what are some of the proposed amendments that you find acceptable?
There are the existing piece of legislation that we have, in my opinion, is very satisfactory. What we see now, subdividing and also increasing penalties, which is largely what this bill is all about, and then also making a tabulation form that will be in electronic version sent, that could be arguably something that is very, very good. So as soon as you get certain documentation from Deputy Registrar, you can send it in an electronic form that can fast-pace the results being exposed. But that does not mean that there could not be a number of wrong things that could have happened before the tabulation is done. Because you can have mischief even under these circumstances. But what I am saying is that there are a couple of things in this bill, that are not very, very well advised, or they're ill-advised, quite frankly. And that is why you're asking me basically for what I think are the good aspects of the bill. Well, I don't really find that the existing legislation covers a lot of the good aspects. Apart from the tabulation electronically that must be posted up, I don't see anything, because the other aspects of the matter of the bill has to do with a lot of attacking the presiding officer, the chief executive officer, and increasing penalties in such a high manner that is totally out of modernity, out of modern reality, sorry. And that is what I would like to emphasize. Timothy is right that we should have gotten here, and you should have done that, a PPP man that could come and tell me what the good side of the thing is. But as I told you just now, it's a poison chalice if you don't get the process right. And then when you see big things like what I've just mentioned as part and parcel of the legislation, you sometimes don't want to give it the kudos that it ought to be given. And as an opposition leader, I'm indicating that these are my comments. It's very, very, unbalanced. There's lots of things here that are very, very critical rather than supportive.
Counsel Jonas?
I agree with Khemraj about the penalties. The whole process has been bureaucratized to such an extent and codified to such an extent that if you ask me, if I wanted to be a presiding officer
Yeah.
at any place, a poll, I would turn down the job. You see, I'll give you an example. If you're a deputy returning officer or a polling agent or an assistant agent or something like that, so any one of a number of officers, this contemplates you get some kind of ID card by the returning officer, and by virtue of that ID card, you have access to the place of poll. And the obligation is on the presiding officer to say to allow you in. Can't refuse to allow you in. Now, if Khemraj is some kind of officer or polling agent, and he comes to me and I'm the presiding officer, and I look at his card, and the signature looks funny to me, if I refuse to let him in, this structure of legislation tells me that I'm liable to $10 million and 10 years in jail. Similarly, if the signature is wrong, but to me it looked all right and I let him in, these laws tell me that I'm susceptible to $10 million fine and 10 years in jail. I'm not taking on a job as presiding officer under those conditions. There is nothing here that talks about knowingly or fraudulently or with knowledge. This is strict liability. So if that card is smudged and I say to Khemraj, you can't come in, I am liable to $10 million and 10 years in jail. That goes past draconian. That is representative of the culture in our society that makes us think that if we have a heavy hand, we can stop crime. It is not the solution. The solution has to be fairness, it has to be transparency, and it has to be simplicity. And that's one of the big problems I have here. And there's a second problem attached to those heavy penalties that are applied so arbitrarily and so easily. In Guyana, we have a history where the government of the day, which controls parliament, weaponizes the police force and the DPP's office. The government of the day uses its power to prosecute and to persecute people that they see as political enemies. We saw it when Winston Brassington and Ashley Singh were shackled and handcuffed after they came back to answer charges. We saw it when Irfan Ali was slapped with 19 charges. We are now seeing it again when APNU supporters who were previously in power are subjected to prosecution. We are seeing government control of police to prosecute the loser. Now, this legislation is drafted by the people who are enjoying the triumph of victory. They would be very surprised if they lost an election and found themselves on the losing end and the other side in power with these penalties and these prison sentences and the power to dictate to the police and the DPP, as happens in Guyana. Go and prosecute Ramjattan, who has lost, or go and prosecute Jagdeo, who has lost. Our governments weaponize the police, and when they take to themselves, using their control of parliament, these kinds of unfair penalties, the whole country needs to be in terror. This is not the solution. The solution is fairness, transparency, and simplicity. And I would like an opportunity sometime in your program to discuss what really needs to be done in the system.
Mr. Ramjattan, how do you circumvent these draconian penalties as is being described here, even if you were to go ahead with some of the intent of the amendments?
Well,
could the language be softened to make way for,
that there will be a need for a lot of that, quite frankly. I mean, I love to go through more than once these legislation, but I managed to get this only recently, and I went through the thing one time. I made some notes that one time, and basically that is what I'm acting on here. But coming back to these penalties, I think it is the intent of the government and the Attorney General who drafted it to make, as Timothy mentioned, a kind of a chilling effect on people wanting to join up, as people would normally do during the elections process. We have about 3,000 ballot stations. So you would normally have 3,000 presiding officers. Then you would have about a deputy presiding officer in most of them, polling agents and all of these. And sometimes the majority of these people come from the public service, teachers and other people and so on. When they hear about this thing, as was rightly mentioned, it will have that tremendously negative effect on them. And, you know, the other aspect of the matter is what you see as happening. Who is it intended to get at? Because when you look at what happened from 3rd of March to August, or whensoever it was not presiding officers, even if we take the PPP's version as to where the attempt to rig occurred. It was not presiding officers and all those people. And almost every one of these, or the majority of these, are getting, one of course got at the CEO and so on, and the returning officer. But why you have to go now, in view of the fact that the presiding officers and so on, they were doing a very fantastic job, to now go and, in a sense, denigrate them to this extent, as if they were the ones that did mischief there. And to that extent, I feel that the thing is out of whack with what we, especially, I'm generally a criminal practitioner in the courts of the law. What you're going to do with $10 million, they wouldn't want to. And you're going to have a crisis in your hands because, quite frankly, you don't want to put, you know, ill-educated people there. You want people who understands the English language and can do the thing, but not be mischievous. And that is where they're getting at. And when they start getting at some people, you're going to end up with people who are not worth being there, and they could do the bidding of an executive branch. And that is also one of the things that is creating so many suspicions of me, because I know, coming from the belly of the beast, how the PPP operates. And it sets up these structures to ensure that it could be the control freak that it is. And it is now doing it largely in a legislative arrangement here. I mean, not only must elections be free and fair, but you have also that which erodes elections is corruption. We saw corruption with the flood relief. None of the what you call corruption there, did they go to the offenses section of the Criminal Law Offenses Act to say, we're going to put a life imprisonment on those who defrauded the government flood relief money? You're not going to get that. But you're going to get this kind of thing directed to a set of people, because that is also an important aspect of the matter. Who are you trying to get at? People who behave badly? It is cavalier, it is sweeping. And a number of the presiding officers, are almost 99% of them, they did their jobs. And you now gone and do all manner of things with the presiding officer. You got to do the same thing like Timothy mentioned, and a whole host of things. And all have been made, you know, so strict. That is terrible. And we did not apparently, or the Attorney General did not apparently go to the Commonwealth countries nor CARICOM countries to find out what are the principles of provisioning for sentences for electoral offenses. None of those countries have those draconian and more than draconian sentences. And, you know, those are the things, when you start thinking about it a little more profoundly, you come to the realization, what are they getting at there? They really want to transform the electoral arrangements into almost a perfect system, or they want to get at some people? And I want attention to be paid on that.
Mr. Ramjattan, in reaction to some of your comments made elsewhere, similar to these tonight, you have been already criticized for essentially wanting to perpetuate what occurred shortly after polling day of March 2, 2020, with all that occurred at the Region 4 returning office, the controversy over more than one declarations, and so on. How do you respond to that by taking such a stance against these proposed amendments?
Dennis, if you didn't know now that it is because of all the confusion that occurred and the confusion that started within GCOM, and of course with the PPP invading and all of that, I did not in any way try to rig elections in Guyana. But you're going to get those people who are going to send in those things to you, making those statements. As a matter of fact, we were told, I remember, that we have to ensure that this process is made right and the recount occurred. And in that, the PPP, as was delivered by the chairman of GCOM, indeed indicated, the results indicated that they won. There are tremendous problems with 47 boxes and a whole host of other things. The thing is highly questionable, with discrepancies upon discrepancies found in that recount process. So if you're going to ask me, because some PPPite who I'm criticizing here going to make a statement in the thing there, I mean, I don't want that to happen here. Because quite frankly, we managed to keep order for 5 months. And it was primarily my ministry and the police force that managed that. And the transition to the PPP occurred in accordance with the declarations as made by the chairman of the Elections Commission. So when people are going to make these damaging allegations and so on, that is the politics of the day. So don't, bring that and say how we're going to deal with it. The trouble is, how could this piece of legislation be modern? And in modern reality, when you are talking about life sentence and so on, I mean, are those people that are writing those things to you listening to us? Or they gone back on a rampage that occurred when they start slaughtering and doing a number of things all over the place?
If the penalties are softened for these offenses, would you be willing to support the amendments?
Well, I was coming to some other amendments. Obviously, if there is the knowingly, in criminal law, you're supposed to have something called mens rea, an intention to do wrong, and not strict liability crime, which do away with mens rea. Knowingly is the word properly used, and simplifying it was what Timothy. You got to put all of that inside there, and then go around the Caribbean, go around the Commonwealth to find out what are generally the legislative arrangements for these offenses. Go back to our England, where we normally take our cue from, and so on. I don't know of England getting life imprisonment and so. And so, yes, that could be supported, because I too do not want that which occurred in that 5-month period. Not again.
Let's move quickly along, Mr. Jonas. Your thoughts about the breaking up of Region 4 into sub-districts. A good idea or a bad one? Because one of the arguments being made by the Attorney General recently in an interview on the SATO National Communications Network is because of the historical problems that have always been there in Region 4 when it comes to general elections. So it is important to break up this most densely populated region into sub-districts, with supernumerary returning officers actually submitting their declarations right up the chain, eventually to the chief elections officer, to the commission, then ultimately a final declaration. Your thoughts on this particular amendment before I come to Mr. Ramjattan on this note as well?
I think it's unnecessary, Dennis. You see, under the legislation, you divide Guyana into districts. We have our traditional 10 regions, and therefore traditionally we divide it into the 10 regions. But there's no need to talk about sub-districts. If you want to divide for electoral purposes Guyana into electoral districts, you don't have to go region by region. So Region 4 can be made into 3 or 4 districts. You appoint 3 or 4 returning officers, and you divide the country into 13 electoral districts. So this complication with sub-districts, I don't see with it. I think that if you wish, create your geographical districts. And in Region 4, which is the most densely populated, maybe Region 6 as well, have more than one district in the region. So that for electoral purposes, Guyana is divided into 13 or 14 electoral districts. It's as soon as we start complicating this thing, we make it opaque, less transparent. The system needs to be simple. We have not yet identified where the problems are. And the problems weren't Region 4. The problems were the Region 4 returning officer.
That's right.
So if we have to talk about individuals, we have a problem. We have to talk about systems. The systems need to be transparent. And one thing Khemraj mentioned, which I think is important, and for me was the first thing. Let me start at the beginning. You got to separate this process into 3 stages. The first stage is creating your list so that the people who are entitled to vote are all on the list. That people are not on the list. People who name appears twice, that can't happen. You need to have a clean list. That's the first system. You then need to have paperwork. So your voting documents streamlined and clearly identified and not forged. So that when people turn up to vote, the process is clear, they know the list is clean, they know the documents are there, they know all the parties are in the station. The second stage is that voting process. And in the station, in the polling place when you go to vote, you want to see a PPP representative, you want to see an APNU representative, you want to see a representative from any other political party with the presiding officer looking at you vote. That's what you want to see, and that's what we saw on election day. Once you have that, you have transparency. No one can quarrel. So you go and you take your clean piece of paper to vote on, you vote, you put it in the box. And then the last stage is the counting. And the beauty of our process is that the counting happens at the place of poll. So there are hundreds of different areas where you're counting. It's not the centralized process that used to happen on the Burnham that you take it out to Ghana and count secretly. It is difficult to interfere with a process where counting is happening under PPP scrutiny, APNU scrutiny, under the presiding officer, and then they take the statement of poll, put it on the door. All of that worked beautifully in the last election. Everybody from both sides on election day, all the foreigners said, good elections, it went smoothly. Where we fell down and where we can create more transparency is instead of putting it on the door, which is a process that is 30 years old from before you had email and websites, you should immediately put this statement up on a website for everybody to see, for me to see, for you, the media to see, for both political parties to see, so that contemporaneously live, the same day as it is being counted, you count in your 800 votes in your place of poll, I count in my 500 in mine. It is going up and it is being tabulated live. So that by 7 o'clock, 8 o'clock, 9 o'clock that night, the whole country knows. The whole country has access. Not by some process that you got to go and look at the door and I got to reach the executable to look at another door and another place of poll. Use the technology. Have it up live. And that will diffuse any nonsensical attempts when it becomes more centralized and all the statements of poll now go to one individual who can corrupt it. It makes his life much more difficult because when he is going through his process of collating these statements of poll, the whole country knows the result already. That's how it needs to be done, transparently. This thing is not difficult.
Totally agree with Timothy there.
Perfectly.
I totally agree with Timothy.
On election day, up to the time they tried to centralize it and brought the statements of poll to a single place in the region where one person started to count it. The decentralized system and putting it up on the door worked, but we're now in a technological age. Don't put it up on the door alone. Immediately use your phone. You're the presiding officer. Put it on the GCOM website. Let everybody, the PPP rep, the APNU rep, everybody there must have it signed off that they could circulate it wherever they want. I could send it to Dennis Shabal. Immediately you have independent people, Kaito News, Starbuck News, everybody, including Freedom House and including Congress Place, tabulating live. who's going to try to undermine that? It will take a brave man the next day as returning officer, and he's doing his duty, recounting these statements of poll to come with a different number than what's on the website and what you have and what I have.
Well, what if he does? What are the safeguards to prevent that from happening?
The safeguard,
In
Dennis,
terms,
is
in
that
terms of, right, I know.
live,
But what are
the
the penalties
signed.
in
Well,
case,
you see,
should he decide to go the other way? He or she, whoever
you
that.
go back to penalties. But first of all, I believe we have solved the problem. If you have signed live statements of poll put up immediately by the presiding officer at each place of poll on a website that everybody can tune into and see, you make anyone's life very difficult when they try to undermine that process.
So that's the singular most important amendment you think you will support.
Yes. The
And
next
you too,
thing,
Mr. Ramjattan.
Yeah, well, I told you already that putting up the tabulated thing on the electronic version is something I support too. But coming back to the subdivision, if you would allow me to make my comments on it.
Sure, Counsel.
Yeah, the law already provide for this general power of GCOM to administratively subdivide any region out of the 10 regions in Guyana and to ensure what is called the efficacy of its work. Right now, as we speak, and the last elections, GCOM had the subdivisions, North Georgetown, South Georgetown, East Coast, and East Bank. But it is an administrative arrangement that they have, and you do not now need, because if GCOM is the general superintendent of the elections, why is it that you want to make the thing written stone now that whatever the boundaries that they have, and Georgetown especially, East Bank, East Coast, they are growing in size, that the subdivision boundaries that you have will then have to come back to Parliament for a further subdivision by the next 2025 elections or some such thing? You know, so it is always important that the general superintendent gets that discretion because it is one region. Now, to go and make subdivide it in a statutory way to make it almost be given a kind of a regionalized configuration is going to take away that that discretion from GCOM, because assuming they got lots more houses going up at Grove or wheresoever, and they want to cut it around for purposes of the subdivision that will make their work far more efficacious, they could do that. They could do that. And so I feel too that this is but a wrong thing. GCOM's discretion as it now exists and as provided for under the Constitution is being violated by an executive branch that has a small minority, one seat only, to then go and take it away. It is not constitutional in my opinion, but I am not going to go there at this time. But it is giving a power that is greater to the executive as against what the Constitution intended to GCOM. I want you to understand my argument because some of these things are very complicated. It's like a judge. Generally, a judge passes sentence. The sentence is 3 years, but a judge has a discretion whether to give you 2.5, 1 year, or even put you on a bond. But the legislation says 3 years is the punishment for that crime. When the legislation now go and say that a mandatory penalty of 3 years, we take it away from judges and we then give the legislative branch. And that is not a good thing. If the people that knows about elections is Elections Commission, they must know and get that power. And that power has worked very well in the hands of GCOM all these years and all these elections that the PPP have won. Some 5-6 elections they won, whatever it is. Why you want to go down and touch a kind of a nest, What you want to do here? I want to know, and especially when you're so suspicious of these people, do they want a platform for a kind of because if they now make it into 4 substantive sub-regions and you got 7 geographic seats and so on, what could be the arrangement they're trying to work out? Because all you got to do is to gerrymander the thing in such a way as to make sure that you get 1 extra seat, and it could mean the winner and the presidency as against another. So I am not really understanding the purpose of it all behind what the PPP is doing here. And I treat this thing very sensitively. If it worked for so long a period in the hands of GCOM, don't let it now be written stone by the legislative branch, and then you do a geographic boundary that because of population growing and emerging and all of that will necessitate, the thing being now written stone that you can't shift it around as GCOM could. So I feel that this discretion was one that was wisely used by all the GCOM people starting from since 1992 and so on. And it should be in the hands of GCOM rather than be taken away.
One quick area before we wrap up this evening's program is the intent to legislate the number of voters at each polling station, and also the intent to ensure that people are allowed to vote, or provision is made for people to vote within their areas of residence or neighborhoods. Is that a good or a bad thing? And should it at all be legislated in the first instance?
I believe that it should be, because that is now coming down to all that what we have been talking about, that you must be like a house-to-house registration. You, by virtue of being with 400 votes to a certain polling station, now in a sense acknowledging that you must have that kind of house-to-house registration. Because I am from Delft Street here, and you have the school Ramakrishna Annex or wheresoever that you go and vote, or in the other school across the street, you have to be close. You have to be close to the area that you will go and vote because you live in that area. And so it is something that I find very appealing and attractive. And that is what by the way, it is largely inside of the arrangement that we had for house to house. And basically, once you are living in 10 Delft Street, Campbellville, you will vote at the nearest polling station. So I find that supportive. The thing about 400, I find that too, because if we could, unless you have a very dense population and you can manage more than 400 votes by not now, having a ballot station that is far away from this very dense population. But at an average, about 400 voters is what, when you take the time and you compute the time from 6 a.m. to 6 p.m., how many voters you could do by virtue of dipping their hand in the ink, dealing with them and all of that, is about 400. That is about the ballpark figure that we come up with. And if they want to put that in, no problem. But there must be 400 voters next to a polling station that is close by, so they don't have to go round all over the place. I feel that is how it should be. It should be commented on, and in that score, those are my comments.
Your thoughts, Mr. Jonas, on this point?
I think that the system already accommodates that. There's a process of continuous registration. If you move, you go and register. The larger problem, I think, is, although I don't think it affected the elections, and I know Khemraj will quarrel about this, will take up on me about this, but the fact is that we have Guyanese who migrate in large numbers. So the population of Guyana changes radically in a 5-year or 10-year or 15-year period because so many Guyanese migrate, die abroad. Their deaths are never recorded in Guyana. And the system to remove those names from the list is porous. That needs to be resolved. And it didn't, to my mind, affect what happened last year, because The system was so comprehensive that you go, they compare your face with your ID card, you put your finger in the ink. The people who voted last year were Guyanese who were entitled to vote. I have no issue with that. I know Khemraj may feel differently. But
How do you see
what
the
I would
issue being
like to
resolved, though?
recommend, yes, what I would like to recommend is that if you are your average Guyanese now in our upwardly mobile society, you probably have a TIN number, you probably have a passport number, you probably have a driver's license number, and you have an ID card number. 4 different numbers you have. I would like to, and an NIS number, I'm sorry, national insurance number. I would like to suggest that, like other countries, we should have a single number. Dennis Shabral should be identified by one number that deals with his tax identification, his passport, his driver's license, his national ID, so that if you do a transaction, if you buy or sell a property, or you go and renew your driver's license, or you go and pay income tax, or you go and pay your renew your driver's license, any transaction you do, a central computer database will say, here is Dennis Shabral, alive and well and kicking in Guyana. And there should be a presumption that if there is no transaction, if you don't pay NIS for a month, you don't renew your license, you don't pay your taxes, things that you are statutorily obligated to do on a regular basis. If there is no transaction for Dennis Shabral for 7 years, he should be presumed dead and taken off the list, so that the continuous process of updating the list will facilitate within a single election period that you come off the list if you haven't paid NIS, claimed NIS, renewed your driver's license, done any of these things that you have to do every month or every 3 years or every year or quarterly for paying taxes. And in that case, when election time comes, you look at the list and your name isn't there, you will have to go to register. But after 7 years, if you haven't done a single transaction using your number in the computer base, your name is taken off. And that will facilitate a continuous cleaning process that you can correct. You might have been abroad for 7 years and you come back. Then you go and register and say, here I am, please put me back on the list. But for those people who have migrated and died, who have migrated and are living abroad, after 7 years, they would have to come and register. And that would facilitate this fear that we have, that so many dead people are on the list. I think that is the solution to the problem. And I haven't seen anyone talking about it. But what it would also do, it would also reduce those people who are doing business under the radar and not paying the taxes.
Yeah.
Because it would be easy for the GRA to say, this man renewing his license, why isn't he registered for NIS and paying NIS? This man's bought and sold a property using his TIN number. Why hasn't he paid any income tax for the last 2 years? So it would create more transparency in our social obligation to our country as well. And I would like to recommend that.
Do you support that model, Mr. Ramjattan?
Oh, I like the idea. I'm glad that Timothy expressed it here. And that is wonderful. I've noticed some other countries have something like that. When doing the constitutional reform process, we understand that in Israel, you have a number system like that. One number that controls the entire thing. And New Zealand. But I noticed that from the letter that Gail sent, that they are doing a set of amendments to the registration of voters under the National Registration Act, which will come as another batch of amendments. I hope that they take that into consideration when dealing with national registration of voters. And there again, a lovely idea can come, not necessarily from the Attorney General, but somebody like Timothy Jonas. And I want to acknowledge the fact that he has brought that up. That will help. It is a useful thing, and hope that that might find itself in draft amendments, the national registration of voters amendments coming up shortly.
But do you have any suggestions in your own on how to continuously clean up the voters register?
Probably I am fossilized, but I like house-to-house registration. Added to that which Timothy just mentioned also will help. The majority of Guyanese in a house-to-house registration exercise exhibits where they're living, and you can have the best system of list that way. And that is get that permanently incorporated into the legislative arrangement, that prior to every election, there must be a list that is accrued out of the process of house-to-house registration.
And to both of you, Counsel, would you be participating in the consultations that you've been invited to by the government?
Well, I got some problems. I don't know about Timothy, but I'm going to probably write to Gail my criticisms that I have just mentioned to you, which have now been made public. I'm going to, of course, also take this to my party. Of course, it is not a leadership thing, but I'll certainly take it to my party. We have 6 weeks, and 6 weeks is a very short time. Must tell you that. But she says that she's going to give an additional 6 weeks after this 6 weeks, but 12 weeks in relation to these matters. And then you got to deal with national registration, which will come up in a couple of weeks' time, as she mentioned here. I mean, these are fundamental issues after that election cycle that we had in 2020. So it is important that, a lot of our people get their hands on the amendments, understand them, and so that they could come up with their ideas as to what could improve and ameliorate the existing situation.
Would you be going to the consultations, Mr. Jonas?
I can't promise you that I'll be going personally, but we certainly will be responding and making suggestions and comments.
Okay, and your wrap-up comments as we prepare to wrap up this discussion. First of all, Mr. Ramjattan.
Well, I'm glad that we got this program to enlighten Guyanese and our sentiments as to what the amendments are and the amendments to the regulations are, the process about it, and our position in it. And I'm glad that you asked me to be here, because sometimes I find these days people are not asking the questions of the Alliance for Change or the AP and UAFC. So I'm glad that you did that here, Shabral. And whatever the shortcomings of my critique, they're all mine. But remember that we're going to do some more studies in it in a larger scale at our executive level. And then we're going to deal with Gail, Ministry of Parliamentary Affairs and Governance, in a way we see fit.
Thank you. Mr. Jonas?
Dennis, as long as we have a winner-take-all system, we will have the mutual distrust, the mutual hatred, and the vitriol that we see now and we continue to see. And neither of the large parties is willing to have that discussion, because when they're in power, they like the power. A system that allows both sides to be present and to share and to be informed will remove the high stakes and will allow representation in government for all of the country, not just half of the country. And the fact is, that is indisputable. You can't escape it. The governments that we have had in Guyana successively have been governments of half of the country. That needs to change.
Thank you, gentlemen. You've been listening to a live discussion on the topic, the implications of the proposed amendments to the Representation of the People Act. Our panelists were Mr. Khemraj Ramjattan, attorney at law and leader of the Alliance for Change, and Mr. Timothy Jonas, senior counsel and the chairman of A New and United Guyana. Good night. I'm Dennis Shabral.
Good night, Dennis. Good night, Timothy.
Take care, Khemraj. Good talking to you. Dennis, take care.